Okay. Can you hear me? Okay. I can't. Yeah. Good. We're going to give it a minute or two. It's just you and I right now. Hey, good morning. How are you?
Hi, Renee.
Hey, Mary Jane, how are you doing?
Not a good time to ask.
Okay. Well, I appreciate you attending. Thank you.
Hmm, hmm.
And who else just joined us? And Terry. Hey, Terry, how are you? I think Terry's still coming online. We'll give it another minute or two and then we'll get going. Okay. Hey, Terry, how are you? Can everybody hear me okay? Let me close this door. Hold on. Okay. Sorry about that. We have a small crowd today, and it's 100% my fault. I didn't realize on Friday and Monday that the email didn't go out. So I don't think anybody got it till this morning and had probably already made other plans. But for those of you that are here, thank you so very much. Greatly appreciate it. I want to be mindful of your time, so let's dive into this. Again, going back to the contract series that we're creating, this is another document that may or may not end up in your contract. I'm sure all of you have seen them. This is the seller's temporary occupancy agreement. It's quite different than the buyers, and we'll go through that in a moment because those are a little more rare these days, whereby the buyer moves in prior to closing. But let's talk about this for a minute. One of the things that I've heard from agents is that the seller wants to stay in the house another 10 days or 14 days or 21 days or whatever the day length is because they're either waiting on a closing or something's going on. So they asked for the temporary occupancy agreement. The occupancy agreement is great. The one rule is right here at top, in the top, is not to be used if it's more than 60 days. If it's more than 60 days, you need to go to a lease agreement with a seller. And the reason being is typically at this point, the buyer is the owner of the property. Okay. So it's a bit, it's a little bit iffy. Now, houses are selling so quickly, there's multiple offers again. And sometimes sellers, are in that perfect storm that the house sells so quickly, they have to scramble to either get out, find another place to live, or get their other home closed on. So you see these quite frequently. And again, one of the things I would always be cautious of is more than 60 days. I mean, I think it's relative, even up to 30 days, but I think anything past 30 days is extreme. Moving on down the form, a couple of things that I want you guys to kind of pay attention to in here. And this is the disclaimer whereby the seller expressly releases the buyer, buyer's broker, and their affiliated licensing from any and all liability of any nature whatsoever, which may arise as a result of the seller's acts or acts of anyone else on the property, including but not limited to liability for injury, persons, damage to personal property, so on and so on. Buyer, seller's broker, seller's buyer's broker, their affiliated licenses, can claim from any claim or loss arising out of or occasioned by the seller's occupancy of the property. So that's a mouthful, especially for this early in the morning. But here's the thing. The one thing that you want to have a conversation with is if whether you're representing the buyer or representing the seller. If you're representing the buyer, talk to the listing agent. The seller needs to maintain their home insurance for the duration of their occupancy. Okay? Very, very clear. Here's the other side that the buyer needs to understand is if the buyer is not if the buyer owns the property, they close, buyer is not occupying the property and the house burns down, buyer's insurance may not cover it because the buyer was not an occupant of the property. Okay, so this short 2-page form kind of outlines the liability of the seller if anything basically happens to the property, and also agrees to hold harmless the realtors and or the brokers and their agents and affiliates. Okay, sellers liable for the expense of repairing any damage to the property caused by seller or seller's family members, licensees, invitees, excluding normal wear and tear. You know, we had a closing last week that was very interesting. I think it got delayed a day or two. The seller hadn't moved out yet. The buyer was there. And when the seller started moving large pieces of furniture, they just tore the hardwoods apart. I mean, deep gouges. And the seller and the buyer were very confrontational with each other. Neither agent was there. Not real sure why the buyer was there, but it was in the process of they just closed and they were moving out type situation. And it boiled down to the point, well, you've damaged these floors. Who's going to pay for it? Well, honestly, what happened was the seller just, for all intents and purposes, just thumbed their nose at the buyer and said, not my problem. Okay. They did not have a temporary occupancy. It was literally 1 or 2 day move out period. They didn't even do one of these forms. So the question arises, even if it's just 1 day, would you guys agree that we would still want to do this form? Any feedback on anybody's experiences? Just unmute yourself. Terry, any comments? I know you've had this. Nope.
I think it's a good idea. I don't care if it's 24 hours.
I agree with that because, basically what it does is it holds, the licensing of the brokers harmless. I think that's very, very important in any transactions that we limit the risk and limit the liability. However, how would a seller go about with such a a buyer approach a seller with such a bad attitude to begin with visible damage on the floor? What would you guys do if you were faced with a situation like that? How would you respond, or what would be your step? Because it needs to be a win-win for everyone.
Whoever damaged the floor needs to be responsible.
100% agreed. And if they refuse, then what happens?
Good question.
Yeah. And I mean, that's literally where we ended up at, because the buyer had already closed, the damage was already done, the seller was out the door, never to be heard from again. So what literally ended up happening was the seller had to come out of pocket I think it was about $375 to get those gouges in the floor repaired. And of course, being the buyer and being upset, they wanted to hold their buyer's agent responsible and the listing agent responsible. But you really can't do that. You just simply have to sit down with them, explain that, there was no, other than what was in the purchase and sale agreement, regarding being held harmless, there was not a lot that we could personally do about it. And I don't even think that the buyer was looking for a handout. I just think that they wanted to rage and vent on someone because the sellers were rude to them, and their brand new home was damaged. So situations like that, I always say, if you need to get me involved, don't hesitate to get me involved. We'll do the best we can, but it's basically just simply trying to get them calmed down, divert the situation, and explain to them what their options would be. And certainly, you can always go straight to it and say, well, you could take them to small claims court. Well, maybe you could, maybe you couldn't. You'd still have to overcome arbitration before you could do that. So it's not always the best way to go. It's just kind of, well, call a lawyer and then you're on to your next closing or next buyer. So it's a touchy situation. Those are some of the things that you guys should always be, thinking about is, whatever transaction I'm in, what are my 4 options if anything goes south? And maybe I just learned to think that way from being a broker, for so many years, because that's when I end up with an issue or a situation is when it's gone south. But you kind of have to look at it from all sides and say, what can we do to mitigate this? And one of that, first and foremost, even if it was just 24 hours, like Mary Jane said, throw one of these temporary occupancies in there. Up here at the top, you can put 1 day till 9 o'clock the next night or day or whatever it is. Further into this, as we go down, if the seller does not timely vacate the property at the end of the temporary occupancy period, seller shall be deemed to be a tenant at sufferance, which is a whole nother level of, you don't want to go there. Shall be unlawfully holding over and shall be subject to being evicted and shall pay buyer holdover rent during the period in which the seller is holding in the amount of blank. You got to make it hurt right here, okay? Because the idea is to get the seller out, whether you're representing the seller or not, and to get the buyer in, whether you're representing the buyer or not. This amount right here needs to be, and again, depending on the purchase or the price of the home, it needs to be substantial. I've seen agents go into these occupancy agreements and put in like $100 a day, or, $0 a day or $50 a day or something like that. If it's $100 a day and I can't get into an apartment or I can't get into my house, that's a heck of a lot cheaper than a hotel. Okay. But this is if they refuse to vacate. So again, maybe $1,000, maybe $2,000, depending on the purchase price of the property. Any questions on that and how it would play in to the rest of the exhibit?
Renee, you had mentioned that before they could take them to small claims court, that it would have to go to arbitration. Why would it have to go to arbitration? Because the deal is already closed.
It's in the agreement. It's in the purchase and sale agreement, the agreement to arbitrate. Mm-hmm. So you have to.
But if it's already closed, that contract doesn't.
Well, arbitration would survive. So what if it?
Okay.
Yeah, what if it closes and a pipe bursts and there's a lot of water damage and the buyer wants, recoup their cost of the water damage from anybody else or from the seller. So, most of the times it would be, well, lawyer up, go to small claims court. No, now they've stuck that arbitration clause into the agreement, along with, it's also in the listing agreement. It's also in the agency.
So that survives.
Yeah.
That's what I was asking about.
Yeah, it always survives. Good question. Anybody ever had a situation where you had a temporary occupancy agreement and the seller refused to leave? Not yet. I hope you don't. I really, really do. But if you do, please bring me in. Let me help you. Whatever I can do, we can do. But again, being diligent about having the right forms and having everything signed off on will go a long way in helping either your buyer or your seller with whatever issues. Second page, you've got special steps here. Special steps would include stuff like, if you're going to be in the house for a week, make sure you skim the pool or rake the yard or whatever. I mean, the seller is responsible for upkeep of the property. However, maybe there's something special that needs to be done, whatever that may be, or whatever other agreements are worked out with the holdover would go into special stipulations and would literally override, depending on what the special stipulation was, anything else in the agreement. So very, very important. And further, it says number 15, buyer and seller are advised to consult with their respective property insurance agents. Have your buyer call them and say, hey, they're going to be in there 7 more days. Have your seller call their company, hey, I'm going to be in here 7 more days. Because just when you let something like that lapse, or you don't have the proper documentation to cover your insurance, then something goes wrong. Tree falls on the house from a storm, house burns down, kitchen catches up. Whatever worst case scenario can happen always happens when your insurance is lapsed. I mean, so you got to be diligent in having those discussions with your clients and customers. And that's pretty much it. Like I said, short 2-page form covers it. And once again, not to be used if more than 60 days. And then you would just go in and label it, whatever exhibit letter it would be next. Any questions on this one? Okay. Now, the rarer form that a lot of people, I haven't seen this in a long time, and it's the buyer occupancy agreement. And it's far different than the seller. Quite frankly, on this document, the seller can pretty much get away with everything unless you're right here with a painful amount if they don't vacate. Okay. So let's flip down here and let's go over to buyer. Okay. Can everybody see the buyer occupancy agreement? Can you guys see it? Just raise your hand if you can. Okay, perfect. Okay, buyer occupancy agreement, paragraph 2. Yes. Hey, Alan. Let me unmute you. Hold on.
I was just raising my hand. I saw it.
Okay. Okay, perfect. Did you have any comment on the seller occupancy? Because I know you've had a lot of experience during the pandemic that left folks in properties and stuff. Any comments on that?
No, it just sometimes I wonder if there shouldn't be an overall clause in the purchase and sale that kind of covers it, because it's kind of one of those things you forget to do sometimes if you got a squirrely seller or buyer.
Mm-hmm.
Sometimes it'd be nice to have that already in the purchase and sale if there's a problem, because you don't discover the problem until later sometimes.
Yeah, I agree with that. And again, it just goes back to being diligent about what's going on in the transaction and how to mitigate it if anything goes south. Thanks, Alan. Okay, on the buyer's occupancy, number 2, right off the bat, immediately says, shall pay seller compensation for the use of the property in the sum of blank per day or blank per month. You can put NA or a monthly rate, however you want to do it, or you could fill out both sides, the daily rate, the monthly rate, however you want to do it. Computed on a 30-day basis, payable advance, and thereafter on the blank day of each month, just like a rental agreement of said property to buyers consummated. Buyer shall pay said rental to blank at the following address, blank, probably seller, for all intents and purposes. So right off the bat, it goes out and The interesting thing about this form is there's no time limit of days on this. The assumption is that they're going to occupy the property until closing. So, that could be 2 weeks, that could be a month, that could be 60 days, but there's no time limit on this. So don't look at this form as a lease agreement for a buyer prior to moving in. If it's an investor property or whatever reason, they can get in there early. If it's going to be, in my opinion, if it's going to be longer than 30 days, then I would just do a traditional lease agreement, because there's far more protections in a lease agreement than 2 paragraphs on a temporary occupancy agreement. And again, depending on whom you're representing, the lease agreement would obviously protect the seller. So if it's your seller, don't accept a temporary occupancy agreement for a buyer prior closing. Just have them do a lease agreement, if it's more than, I would say, 30 days. Otherwise, you don't have that protection. Further into it, buyer has paid blank to holder as an escrow agent, blank amount by check. This is earnest money, folks, and it may or may not be refundable. Or security deposit, basically. It may or may not be refundable. It's held over in case, for whatever reason, they don't close and the buyer ends up moving out. Right here, in the event the sale is not consummated due to default of buyer, seller shall be entitled to receive from holder all or that portion of the security deposit necessary to compensate seller for any unpaid rental payments, accumulated late charges, or return check charges, and the expense of repairing any damage to the property caused by buyer other than normal wear and tear. So very interesting. I've seen these left blank, and I've seen this filled in, sure, $50 a day, $30 a day, whatever it is, but not a security deposit. If I were the seller, regardless if I'm an investor and I have 47 properties or whatever, if I have a buyer moving into my home that is not closed yet, you better believe you're going to collect a security deposit. Because just like I said, worst case scenario, boom, something could happen. He doesn't close and there's damage to the property. This is interesting. These 2 paragraphs are interesting. Well, not that one, but this one. Okay, buyer will accept property in the present condition, except as provided in the amendment and or as follows. Okay, it's encouraging your buyer to have an inspection done prior to moving in. A diligent and prudent, competent inspection, including conducting final walkthrough, examining, testing, surveying property, whatever, because you figure right now, if they're going to take occupancy of the property and they're going to move in, then go ahead and get it out of the way. They're going to do an inspection regardless. Okay, because once they move in, any damage, above normal wear and tear, they're going to be responsible for. This is, as a seller, again, not a great thing for the buyer, but as a seller, it's a great way to negotiate repairs that you may or may not want to do on your home that you're selling. And I'm not saying use that tactic, but again, you have to look at it from all 4 points and just simply, how do we use the forms to our best ability? And it says further in here, this inspection of the property shall include, but is not limited to, termites, wood destroying organisms, I apologize. All appliances remaining with the property, heating and air conditioning systems, plumbing, including without limitation, sewer, septic, water well, pool and spa, electrical, roof, gutters. It's the whole 9 yards right here. Okay? Any radon testing, any mold thing going on. Because here's what's going to happen if that does come up and it's severe enough, you're going to have to, as a seller, address those problems. And again, they are moving in ahead of closing. It's tricky. Okay. Further, buyers shall make no alternative repairs or improvements to the property without first obtaining the prior written consent of the seller. So again, they can't, just because they're going to close and everybody's confidence they're going to close, but we're still 21 days away. They can't just come in and start painting or remodeling or doing anything like that. Okay. So you've got to just, if you represent the buyer, just notify them this is temporary. This is temporary, just like it says at the top of the form. Further, the responsibility of the seller for the property shall end upon occupancy of the property by buyer. So the seller kind of, after the inspection, and once that's negotiated, then the seller steps back and the buyer is solely responsible for carrying the insurance, paying the utilities, whatever was agreed upon in this agreement, then they have to perform. And in the event that the buyer makes any alterations, repairs, improvements to the property in accordance with paragraph 6 hereof, paragraph 6, buyer agrees to indemnify and hold harmless seller, seller's broker, buyer's broker, and their affiliated licensing from any claim or loss, including reasonable attorney fees relating to personal injuries or property damage caused by arising out of the making of said alterations, repairs, or improvements. So very, very, very important. You counsel them, do not make any major repairs, do not paint anything, don't tear down a wall, because they're going to have to put that wall right back up again and restore the property to the condition that it was in when they took occupancy. And it would be solely and wholly and completely upon the buyer to make those repairs. Okay. Now, again, further down on page 2, we have special steps. If you come to an agreement between the buyer and seller, and they say, hey, we're going to paint the living room or we're going to paint the bedrooms, and, this is the color we're going to paint it in, and everybody's happy with that, that can be on your special steps, and none of that would apply. Now, again, if it doesn't close, the seller is going to end up with their bedrooms and their living room painted or whatever else was agreed to. Again, buyer shall have all utility records changed over to buyer's name and shall pay all utility service and fees commencing on the date of occupancy. Seller, at seller's expense, retain fire and extended insurance coverage on the property until the date of closing. Again, you've got to have that insurance conversation with your buyers and your sellers on any type of occupancy. Buyer acknowledges that this exhibit merely grants the buyer a right to occupy property prior to the consummation of the sale, so long as buyer is not default under the terms of the agreement in this exhibit. So if they haven't tendered their earnest money or, something else is going on in the transaction, they can't enter into an occupancy agreement. Just FYI. And then further, here's the hurt zone. If buyer does not immediately vacate, buyer shall pay seller a daily holdover fee of blank. And here it is. This is the hurt zone. Make it hurt right here. Seriously. Further, on paragraph 11, if any payments are required by this exhibit are not actually received by the seller or seller's broker on the date, seller shall give buyer written notice of default, has to be in writing, and buyer shall have 5 days from the date of the notice delivered to make the payment late fee to seller, or seller shall have the right to terminate the agreement by giving buyer written notice thereof. Okay. It goes on to further say buyer shall pay to seller an additional amount equal to blank percentage of the payment due as additional rent. This is where your payments due, and this would be the percentage. It could be 10, 20, 30, 40, 50, or 100%. Again, all negotiable, and it's up to you to have that conversation. Further, unless prior agreements are made, no pets allowed, and that's a touchy subject. And I'm going to tange off here for a minute and talk about service animals. Got a call last week from one of our agents who's leasing a property, And a lady came to them and had two service dogs. She claimed they were service dogs and was only able to produce a certificate of security from a vet somewhere in Baltimore, Maryland. It was not an official documentation that these were her support dogs. And basically, what she was trying to do was to get out of the $500 per pet fee that the landlord was going to charge them. So please be very aware, service dogs and what do they call those? Support animals are two different things. A service dog is far more involved. They have papers, they're certified, they're trained. You know, a comfort animal like, a bunny rabbit or a cat or whatever like that, somebody showing up with just a letter from a vet from somewhere saying that this person needs this animal for anxiety is not going to fly with a lot of landlords. So if you're representing a tenant or you're representing the landlord, be very, very strict with that. Because again, pets can create, and I'm a big pet lover, don't get me wrong, but pets can create a lot of damage down the road. They get nervous because they're in a new place and they, chew up the spindles on the stairs or they chew the stairs or something happens. Because, they're in a stress situation too. So you've got to be very, very careful how you handle it. And just because somebody gives you a piece of paper that says they're okay, take it one step further. It goes on to say, in the event the sale is not consummated for any reasons, buyer shall be liable for the expense of repairing any damage to the property caused by buyer, normal wear and tear accepted. So again, any changes, they're going to be responsible. Seller, this is important. Seller shall remove seller's personal property from the property prior to occupancy of the property by buyer, except for those items that are to remain with the property as set forth in fixtures checklist attached hereto and incorporated herein. So that'd probably be your seller's disclosure because it's got the fixture list on it. But if your seller leaves a refrigerator in, let's just say in the garage, like, a beer refrigerator or something like that, and the buyer is going to close and it's pretty much a done deal, but now they've become enamored with this refrigerator, seller might not have a claim on that anymore. So maybe that's something that needs to go into special steps, that the seller will leave it until closing, but will then remove it. I would personally just tell the seller to go ahead and get it out of there if it's going to be that big of a deal. Any comments on this form? Because like I said, we don't see these as often as we used to. But with some investors, we do. So any comment? Please go ahead.
I have a question back to this service versus support animal.
Okay.
Because I do lease out quite a few properties.
Okay.
I've had people come to me and say, well, I have a support animal. Is that covered under law as well as a service animal if they don't have anything but that piece of paper from some vet? I mean, where does the liability lie in not renting to them? Because I've had people say, well, you have to rent to me. Somebody had a freaking Great Dane and people didn't even want a dog in there.
The animal has to be designated a service animal by the state, county, or even city where the property is located. So if they're moving to that place, they either need to go to the county or the city and find out if it's a special certificate, or maybe it's even filed with the state. But it's got to be from one of those three authorities to be considered a service animal, not a personal support animal. And that's what I was talking about with the crazy letters from the vets, that come, any vet can write that. Maybe it is true. Maybe they need their pipe or something, but it's not a service animal unless it's got service papers. And I doubt seriously the state is going to consider, ferrets or snakes or bunnies or birds or cats for the most part as a bona fide service animal. You know,
Okay. That was my question, because I had this one guy who walked in and I said, well, the owner doesn't want pets. Well, it's against the law, blah, 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 blah. And he just went into this whole
sure he did.
thing of how he had to have this emotional support dog.
Right.
Whatever.
But
Okay, so I'll just tell him he has to produce the papers from the whatever
burden,
jurisdiction.
correct. The burden is upon the tenant or the buyer to produce those papers. Or you have a pet policy, you know, that you can add in special steps if you wanted to. But the burden is upon the buyer to present the proper documentation, not a letter from a vet. It's literally a certificate, because I've seen them. It looks like, you know what certificates look like, but it's literally a certificate.
Okay.
But good question, you know, and that happens as well. And, you know, my thought is, and again, you know, it's the landlord's property. The landlord has the right to decide whether or not they want animals in their properties. And I understand that there are laws and stuff, but only typically applying to service animals. And typically those are dogs. But there is a gray area with those support animals. Some are like, okay, you know, give us $1,000 pet deposit and you can have your Great Dane or whatever. But like your client, like you had, was not willing to do something like that.
Well,
But
not only that, but the kid told me, well, and somewhere in the lease thing is something about they can't require a pet deposit if it's a service animal.
if it's a service animal, no, but not a emotional support.
Emotional support. Okay.
Correct. Yeah. Yeah. There's two distinct differences. Two distinct differences. And if you've ever seen a service dog, you would know immediately that this is a service dog, because, you know, typically they wear those little vests. I've seen them with the vest, but they're very attuned. Like, you know, if their owner has like epilepsy or, you know, something like that, or they're blind or deaf or whatever, those service dogs, you can tell immediately that it's a service dog. I mean, you just can. So
I have a friend who actually trains the specific service dogs.
well, you know what? Next time you talk to them, find out, you know, where does the certificate come from? Does it come from the state or the county or the city?
Okay, because the dogs that she trains do detect epilepsy and diabetes and all that.
And those
stuff,
are valid service animals. Those are not emotional support. Those are valid service animals. You know, but yeah, I'd love to find, and I should probably have done a little more research, but that was kind of a side thing that I brought up because of what happened recently with the emotional support animal, and wanted to get your guys' feedback. I value it. And, you know, you have the most experience out there doing, working with those types of situations. So, but that pretty much, again, takes us down to special steps. And then the end of the document. So you have two distinct documents, very different. I think the buyer's occupancy agreement's far stricter than the seller's. But then again, you're limited to only 60 days on a seller. In my opinion, I wouldn't let it go past 30 days unless it was just a super extenuating circumstance that they had to have the full 60 days. Go to a lease agreement. It's just more protection for the seller. So any more questions? There is, I got an email today because I've had a lot of questions about this. Let me see if I can pop this email up and find it. Hold on. Okay, this was on. Hold on one sec. Let me find it. This was on from FMLS. Okay. Okay, hold on one second. Let me go and get, this is a new thing that FMLS sent out this morning regarding listing status. So since we have just a moment here, hold on, let me run and get it. Hold on, it's in my office. Okay, hold on. All right, so this email came to brokers and admins this morning. I can't pull it up on screen. I didn't plan ahead, but it's talking about the most recent thing called registered status. Has anybody heard of registered status? Okay, no. Okay. I'll send this out to you guys along with the link to the videos after the meeting, but let me just real quickly go through this. Okay, registered status. What a registered status is that you're required to put in your listings into FMLS within 48 hours of signature. But some people, and again, because it's such a hot market and low inventory, they might not necessarily want that listing to go live. So how do you stay in compliance? So they've created this status called registered status. Okay. And if you move the listing to registered status, it is like on hold indefinitely. Okay. And here's what it says basically. Register status is a great way to obtain an exclusive right to sell agreement, even if your seller is not ready to begin marketing the property. You can enter a partial listing into FMLS within 48 hours of receiving the signed agreement. However, only the listing agent and broker can see registered status listings. You cannot market a registered status listing in any manner. Okay. So, and they created this to keep everybody in compliance because coming soon did not serve that purpose. You know, once you put it in under coming soon, it went out to everybody. It even aggregated to Zillow and Redfin and Realtor.com and all of those, which I thought was crazy because coming soon, in my opinion, means we're coming, but we're just not there yet. So registered status has been created. You know, if you're in a situation where you have a signed listing, they're not ready to put the sign in the yard, or they're getting the house painted, or they're replacing windows, whatever, move it under registered status. The next thing they talk about coming soon is another option if you have a signed listing agreement and the seller is ready for you to market the property, but does not allow showings. Okay. Coming soon listings are visible in Matrix and Remind and other FMLS participants, which is the aggregation to Zillow. Yeah, I lost my place. Coming soon with Matrix, Remind, and other. Okay. It can be disseminated through IDX data feeds displayed on public portals and on other authorized websites. Coming soon listings can remain in that status for up to 30 days. But to be very clear, nobody may show or preview the property during that period. To reinforce the point, no showings are allowed and no other agent or broker can access the property for any reason. Did you guys know that about coming soon status? I didn't. You know, we've sold homes under coming soon status, and apparently that was a violation. We didn't necessarily know that, but that's exactly what it was. So be very, very mindful. If it's not going on the market, put it under registered status. Coming soon, can't show it, can't have any brokers through there, can't do an open house, but it will aggregate out to everybody or to everybody, to every platform on the web, basically, which is bizarre. So I don't know. That doesn't even make sense to me.
Can you have a coming soon and stay in that status for 30 days and go, oops, I want to go back to registered status?
No. If once you select anything other than registered status, you can't go back to registered status. I do know that.
I was thinking of a seller that might want to be coming soon and they keep coming for 6 months, right?
Yeah.
Looking at all those guaranteed offers or some stuff like that or something. Who
Yeah.
knows?
Yeah. Well, and further on those guaranteed offers, people like Orchard and Knock and Open Door, if it's listed, they will not even talk to a seller. They will not even have a conversation with them about purchasing their property, regardless of the status. If you have a listing agreement, they can't talk to you again because it's an exclusive right to sell agreement and you're already rep, so they cannot talk to you. And if they are talking to them, then the seller hasn't been honest with them. But they can still look that stuff up if they wanted to. So,
Well, couldn't they still make an offer?
not if it's listed. Well,
See,
I take that back. I think Open Door could because they do the buy side of it. Knock, not so much, and I don't think Orchard would. But don't quote me on that. I don't work for them, so I don't know 100%. But that's just based on experience of a couple of people that have attempted to use these iBuyer companies that I know of to sell their properties. It's quite expensive. And, my thought process and advice to them was, you have a real estate license. Don't turn it over and spend tons of money just because you don't have time to deal with it. Do it yourself. That's the best advice I could give a realtor that wants to work with an iBuyer company. So, but anyway, I digress. So, I will get this video uploaded. We're coming right up on the 12 o'clock hour. I want to be mindful. I will get this video uploaded with everything else. I'm going to send out the email that we got from FMLS today to everyone, as well as the link to the videos. And I promise you there will be a meeting next Tuesday. I think I want to go over referral agreements. And here's the reason why. We're getting a lot of them in-state, multi-state, and across the Chapman Hall companies. So I kind of want to talk about that because we have agents that are in realty that are referring to realtors and vice versa. So, and we still have to do referral agreements because it's separate brokerages. So I want to talk a little bit about that. Plus, John and I took a class with Seth Weissman yesterday. It was a law class, and it was titled Scenarios That Can Get You in Trouble. And they had some interesting comments about referrals, and I think it'd be a great time for it because a referral is not maybe necessarily part of an agreement, but can directly be affected by agreements, especially in other states. So we'll talk about that next week. Does anybody have any closing comments or anything they would like to talk about or any questions that you might have before we wrap it up? All right, everyone. Thank you so much for attending. Greatly appreciate it. All of you to step in today on such short notice. I really, really appreciate it. I hope you enjoyed these classes because I really do. I just really enjoy them. I like talking about them. So thanks, everyone. Have a great day.
Thanks, Renee.
Take
Thank
care.
you.